SJC-11576, John F. Zullo v. Culik Law, PC, and another.
Yes, sir. Good morning.
Good morning, Your Honors. If it pleases the court, my name is John Zullo. I am the plaintiff appellant in this matter, and this is an appeal from the single justice, the Honorable Justice Botsford, in case number SJ 2013-0276. What I'm asking the court to consider today is, can an attorney whose fee agreement is null and void by its own terms compel an arbitration, which is listed in that fee agreement, and does the Legal Fee Arbitration Board in Massachusetts have the authority to hear matters of law? Number two, does the doctrine of res judicata, issue and claim preclusion, bar forever any further litigation of that matter? And number three, what exactly was the Massachusetts State Legislature's intent regarding MGL 218, Section 23 regarding small claims matters? As a brief statement of the case, I'd like to just, if I may, list out about 15 dates of what has transpired in this case, which will bolster my claim that this is an extraordinary case pursuant to 211, Section 3. I attempted on a pro se basis to litigate a case regarding my home. I lost badly. I then set out to interview attorneys. I interviewed 5 attorneys, Mr. Culik being one of them, and his law firm. 2 attorneys didn't want to take the case because it was, in their words, too cumbersome. 1 attorney informed me I had no case. 2 other attorneys, including Mr. Culik, indicated very interesting case, very strong argument. Based on those discussions, I selected Mr. Culik, had my first visit with him on April 5th, 2011, which time he reiterated his position, because I did have a phone conference with him. He reiterated his position, said he would need $4,000 as a retainer, and gave me a fee agreement that day, which he signed on April 5th. I explained to Mr. Culik I had to get back to him because I wanted to get back to the other attorney who was in the running. And on May 30th, I decided to hire Mr. Culik and paid him the money. After that initial interview and one of the office interview appointment with Mr. Culik, he was very difficult to get a hold of. He eventually would call me back, and then eventually the money ran out, and all of a sudden I had no case. Never received a statement what he was doing with my money. And when he told me there was no case here, he sent me a bill, my only bill, and said that he used up the money. On January 11th and February 13th of 2012 now, I made 2 separate 93A demands of Mr. Culik. First one he said was improper. Second one, I went to an attorney and they helped me prepare it. And he turned both of those down. He did respond. He turned both of them down, never mentioning arbitration, never mentioning anything, now saying he never indicated that he had a case. Okay? On April 26, 2012, I filed a small claims matter in the Woburn District Court, and they scheduled a date for July 2nd, 2012. We were notified of this on May 8th, 2012. We got the notice in the mail. Didn't hear from Mr. Culik during any of that time, and I do understand under a small claims matter he's not obliged to respond. I do understand that. However, 5 days prior to that, he files a motion to compel arbitration. I objected to that on the 29th of June, 2012. That very same day, he sent me another opposition asking that the case be continued as he all of a sudden was called away to another court. In any event, on July 2nd, he showed up. The clerk magistrate, Mr. McDonald, explained to him that the motion was filed untimely, and to which Mr. Culik's response was, then I will argue arbitration as an affirmative defense. Based on that, Mr. McDonald scheduled it for the 29th of October so we could tend to arbitration. A letter dated October 1st, 2012, which we both received, and Mr. Culik's is stamped October 8th. I received mine on October 8th also. Gave us a arbitration date with the Fee Arbitration Board for November 6, 2012. I immediately received a phone call from Mr. Mark D'Antonio. I believe he runs, or he's the lead attorney over there. He has a title over there, I'm not sure what it is. Who, first thing he wanted out of his mouth, what's the status of the 93A claim and your small claims matter? And I explained to him what I have just explained to you folks. He said, okay, you do understand, all we're here to do is argue the fee. I said, I do understand that. He said, so don't bring any, you can't argue anything else. In addition to that, within 4 days, matter of fact, on October 12th, Mr. Culik sent a letter to the Woburn District Court removing my case from the list entirely, stating that we're going to arbitration, there is no more case. And I'm the plaintiff in that case. He's the defendant. I then went to the website of the Fee Arbitration Board, and it says in 3 different spots, we don't want to hear anything about attorney misconduct. We don't want to hear anything else. We are here for fee. It's paramount throughout the whole website. In addition to that, the day we went to the Fee Arbitration Board, our arbitrator gave us a set of instructions in the first 15, 20 minutes, indicating that, listen, I see all the papers, I see the 93A, we're not addressing that. We are here to determine if the fee he's charged you is reasonable, and if it's not, what you're entitled to as a refund, if anything. When we argued our case, I'm sorry, I'm nervous.
Relax.
I'm fine.
Doing a good job.
We argued our case, and again, his fee agreement come up. This was a case, I was going to argue this in the small claims, but I never made it that far. And on the bottom of this man's fee agreement, it says, if the fee agreement is not signed by the client within 30 days, it's null and void. Period. It's in small print down the bottom, but it's right below where the signatures are. He signed it on April 5th. I signed it on May 30th. So he then indicated that Quantum Mirror would take over. And, but basically, the arbitrator was very nice. He heard our matters, and subsequent to that, he determined that $1,350 was due as a refund, even though Mr. Culik denied any sort of settlement pursuant to 293A letters.
I take it you got the refund and then we're back in small claims court.
Yes, I went back, but again, on December 3rd, I had a hard time getting it back on the list till the clerk of the small claims area downstairs in the Woburn District Court realized, oh, she says, you're the plaintiff, you didn't take this off. So she brought the case back up, but we had to set up a new date. The clerk there indicated, because he was claiming res judicata, and that I accepted that. She instructed Mr. Culik to file a motion to dismiss and gave me 14 days thereafter to respond. And she set our date for another hearing on February 28th. We're now into 2013. We went there that day. We argued the motion to dismiss, his motion to dismiss, and my opposition to that motion. Now, initially, the docket sheet that Mr. Culik has submitted indicates that the court denied his motion to dismiss. However, I got notices saying there was judgment in favor of the defendant. I then filed a motion for clarification, and and the decision came through just listing Culik law. It didn't list Mr. Culik. So under the clarification, she added Mr. Culik, but made no further comment. I then filed a motion for reconsideration, which was 28 pages. dropped it off at 1:37 on a Friday, April 12th. Yes, on April 12th, and dated on April 12th was a denial which I received on that Saturday, the very next day. No reconsideration was given, in my opinion.
You know, Mr. Zullo, now, you've given us the chronology, and you see the red light
I do.
blinking. So, but I want to give you an opportunity to try to summarize briefly what your argument is. So you've given us all of the background to get us to where we are. What would you like to say?
What I'd like to summarize is that this is not a case where res judicata affixes to it, because I never had the opportunity to present any legal matters before the fee arbitration board. I was denied every step of the way, and other than 2 motion hearings in the district court, that was the lump sum total. I never had my day in court. And I know that Mr. Culik is citing Tessima, Pandy, as reasons why I got my, a small claims person cannot appeal an adverse decision that they get out of a small claim. You kind of waive that. But I never got my date in court. In all these cases, Tessima, Pandy, Stevenson, McGinnis, they all were before a judge. They argued their case. I never made it that far, period.
All right, thank you.
Thank you kindly.
Good morning, and may it please the court, Joe Culik for the appellees. I'll rest on my brief except to just briefly say that Mr. Zullo has not met the standard for an abuse of discretion or an error of law. There was a trial held in this matter. There was also the fee arbitration. His Exhibit 9 is the trial decision from the magistrate. There was a motion hearing and combined trial hearing. The arguments that he's making today are essentially the same arguments that he made to the single justice and the same argument that he made in the small claims hearing. Under the small claims statute, it's clear there is no right for a plaintiff who's unsuccessful to appeal. Mr. Zullo's had his day in court, and I'll rest on our brief.
All right, thank you very much.
Thank you.
All right.